Yes.
So, Mr. Mugambi, when you said the Doshi form, is it like Chuma la Doshi? Hello and welcome to Legal Basics with Sarah Law Global, and my name is Sian. Still on the employment law series, today we have a very interesting topic, and that is work injury. And I'm so excited because today we have with us a colleague of mine who is going to have a discussion on the legal issues surrounding work injury. And without further ado, I will let him introduce himself. Welcome, sir.
Thank you, Sian.
Thank you.
Hello, viewers. My name is Mugambi Mutua. I'm an advocate of the High Court of Kenya. I practice in Mombasa with the firm of Hamilton, Harrison and Matthews. It is my hope that this discussion will be beneficial to all of us, and it will shed a little bit light on the issue at hand. Thank you.
Thank you so much for joining us, Mr. Mugambi. Once more, today we're going to be discussing work injury. Now, Mr. Mugambi, I'd like us to go through the obligations of an employer and the obligations of an employee as far as safety at the workplace is concerned.
Thank you, Sian. Foremost, work injury is straightforward as the word goes. Work injury relates to injuries at the workplace. So what we have in mind, or what our viewers should have in mind, is when we talk about work injury, we have in mind injuries that may occur at the workplace or diseases that may occur at the workplace. These are what is commonly known as occupational injuries or occupational diseases. As we know, every engagement that someone undertakes has the potential of causing harm to someone. Now, at the workplace, it becomes more so important because in most workplaces, you deal with machines. In most workplaces, you use your body to perform the tasks that are given to you. And it is expected, or it is elementary, that someone might either be injured while doing what you're supposed to be doing, or the work that has been assigned to you by an employer. So the question is, first of all, what are your obligations as an employer, and what are your obligations as an employee, and what are the rights of all the parties that are involved in this relationship? So foremost, the first duty is on the employer to ensure that they maintain or have a safe working environment for their employees. And in order to ensure that this is done, the first obligation is to provide something we call protective gear to an employee. Depending on the kind of work that you're doing, for instance, where machinery is involved, you as an employer are supposed to make sure that your employees are protected so that they do not get injured while performing the tasks that you've given them. For instance, I'll give an illustration of a construction site. You need to give your employees helmets. You need to give your employees gloves. You need to give your employees gumboots. You need to give your employees gloves. The kind of protective gear that you need to give your employees will depend on the work that you're doing or the work that they're engaged in. For instance, I would not expect that someone who works in a let's say white collar job or in an office to be given an helmet. That would be preposterous. And at the same time, you would not expect someone who is going to a construction site not to be given an helmet or gloves. So that is the first obligation as far as an employer is concerned. And this is a two-way street in that, in as much as the employer owes you a duty of care in making sure that there are safe working environment, you as an employee are reasonably expected to take care of yourself, to make sure that you do not engage in acts or actions or omissions that might cause you harm or your fellow workers. So I would say a reasonable man, the standard of a reasonable man is used in this kind of expectation, in that you do not expose yourself to injury just because maybe you do not want to work, or maybe because you see there is an opportunity for compensation, as we later on find out during the discussion.
Okay. Now, the obligation of the employer to provide a safe work environment, is it transferable to an employee? For example, if I was maybe working at a construction site, and part of my employment terms, for example, the employer says, come with your own helmet. Would the law presume that this obligation has moved from an employer to the employee?
I would think not. I would say not, because the obligation is statutory, mean that it's provided under the law. It is the employer who has this obligation. Under the law, you cannot transfer your obligation to someone and then expect that, wait, I told you to bring your helmet. Now, if you did not bring your helmet, I am not answerable or not responsible. That is not what the law expects. If you're supposed to perform a certain act as an employer, you should do it.
Okay. Now, does work injury only relate to things that happen in an instant? For example, somebody at a construction site hurting their body, or does it also apply to things that happen to people in the course of time? And I would give an example, maybe a person who works in a lab and has been exposed to radiation for a while, and with time that radiation causes their body to be sick. Or even in a white collar job, a person who sits with a laptop for many years, and with time their vision starts to deteriorate. Would that also classically be considered as work injury?
Absolutely. When we talk about work injury, we do not mean construction. The example, the illustration I gave about a construction site was just one of the example. Mm-hmm. Work injury relates to everything, every injury, every disease that is, let's say, that you get or that you suffer while working, be it in a white collar kind of job or the manual kind of jobs.
Okay.
Yes.
So now an employee has realized that maybe now I have tested positive for a disease that came to me because of exposure at my workplace, or somebody has gotten injured at their workplace. Where do they start?
Thank you. Now, once you get, unfortunately, when you get injured at the workplace, the first responsibility as an employee is to report to your employer. You inform your employer that you've been injured. How do you inform your employer? Through your supervisor. You can make this report orally or in writing. Now, once the report has been received by your employer, the employer is required to take measures to ensure your safety. The first step the employer should take is, if let's say it's bodily harm, he is supposed to make sure that either you're given first aid or taken to an hospital. That is the first step, so that to get ahead of the situation before it deteriorates. Now, after an employer receives your complaint or receives your report, they are supposed to document it. So this is an obligation to an employer. The moment an employee reports to you that they've been injured at the workplace, you are supposed to document that incident. You're supposed to notify the labor office, mm-hmm. and then the labor office will take the necessary steps to investigate or to find out how this accident occurred. Now, the investigation might not be necessary in instances where the report, or where the report made by the employer is not contentious, and where everything has been said. So there's no need to go and investigate that which has not been controverted. Okay. So there is a particular form an employer should fill. It is commonly known as the Doshi form. So the employer will fill that Doshi form and submit it to the labor office. Mm-hmm. Now, the labor officer will take the Doshi form and go through the filling, and there is a particular part where you're supposed to also do the filling, the official filling. And one of the reason why this report is made to the labor officer is for the labor officer to assess the compensation that is payable to the employee as a consequence of that action, or that as a consequence of that injury. So the labor officer feels, and there is a particular there are particular guidelines in under the law which will guide the director in filling or in assessing and to determine how much compensation is to be paid to the employee. So after the director does the compensation, he should notify the employer, this is how much you should pay. And generally, it is expected that the director will also inform the employee that this is how much you should be paid. Okay. Now, an employer is expected to take out insurance. It is an obligation under the law for an employer to insure all his employees against work injury. So it is expected that the employer will communicate this assessment to the insurance company for compensation. The employee should not, most employees do not know this, and it is not in their place to ask the employer whether you have communicated the compensation that should be paid to me to the insurance company. All that employee knows is that I'm supposed to be paid this much by my employer. So the only aspect of you taking out insurance, an employer taking out insurance, is just under the law, but the employee is not supposed to expect or to know or to follow up the insurance for payment. All he knows is that it is my employer who is supposed to do this compensation. Now, let's say as an employer you have received this assessment from the director, and you're not comfortable or you're not agreeable to the compensation. Okay. You have 30 days to lodge your objection with the director. The law provides the forms which you can use to lodge the objection, and the director is supposed to more or less like consider your objection and make a decision on that. Similarly, as an employee, if the assessment by the director is not appealing to you, you can also exercise the same right and lodge your objection in the required format. The law expects that if there is no objection to the assessment should be paid within a period of, it's 90 days, I think. It's a period of 90 days. So if an employer fails to pay the compensation within the 90 days, the law provides that that is an offense. Unfortunately, the challenge we have at the moment is that the law does not provide for ways on how an employer, or an employee rather, can enforce the assessment that you receive from the director in case an employer does not pay. At the same time, it does not provide for the prosecutory powers of the director in case an employer fails to pay, and after the stipulated number of days, and a crime or an offense, so to speak, has been committed. So the law as it is at the moment, I can say, provides like a guideline on how the compensation or how an employee can claim compensation, but unfortunately does not provide for the enforcement. So at the moment, what employees have been doing over time is to approach the courts and file their cases in court and ask, or rather claim compensation from the court. That has been going on for a while, but at the moment there is a lot of confusion emanating from a decision by the Court of Appeal and a decision by the Supreme Court, which essentially provides that the courts where these cases have been lodged in the first instance, the magistrate courts, do not have jurisdiction or the powers to adjudicate over these crimes. They expect that the director is the one who is supposed to do the compensation and to assess the compensation and advise on how much is payable. So there are a lot of cases pending in our courts where I can say employees have been disenfranchised because they do not know what to do.
Okay.
Now, as we started this discussion, we said that perhaps by the end of it, we'll have shared our thoughts on how an employee can claim their rightful compensation. Now, if an employer does not pay within the requisite period of time that has been provided under the Act, the employee is not destitute. The employee can file an enforcement action at the Employment and Labor Relations Court for the court to enforce the assessment by the director. So that's my view on the matter.
Okay.
Yes.
So, Mr. Mugambi, when you said the Doshi form, is it like Chuma la Doshi?
Okay. No, it's not. It's a form. It's a statutory form that is provided, and the Work Injury Benefits Act. It's certainly not what you referred to.
Good. It's important to clarify. But just as we wrap up, I would like you to explain the form of this compensation, because sometimes when people get injured at work, they have their own expenses towards their rehabilitation, towards their medication, and then there's now the fact that you're being compensated just because you're injured. So now, in the event that this assessment is lower than what the employee has spent to treat themselves, what recourse do they have?
In an ideal situation, it is expected that the employer is the one to foot all the medical bills. The employer is the one who is supposed to refer you to the hospital. The employer is supposed to take up your treatment. That is what is expected. So as an employee, it is not expected that you're going to foot your bill. So if you foot your bill, it's an unlikely scenario, but it's a reality that we have to be alive to. So I would propose that if you foot your own bills, make sure that you maintain all the records and all the receipts and submit them to the employer when you're making your claim, so that the employer can refund you. So the compensation is it's more or less like a mathematical kind of endeavor. It's not like something that is at large. The Act provides, there's a schedule under the Act, the relevant Act, which provides the amount of compensation that you're supposed to be paid for particular injury. So it's more or less like the employer or the director will assess what you have, or just go to the Act, see this employee has suffered ABCD. What does the Act provide? What is the level of compensation to be given? Sometimes it might be the employee might have suffered some permanent incapacity as a result of the injury. The Act provides for this. You just go to the relevant Act, to the schedule, and it provides for this form of injury. This is how much injury you've suffered, or this is the permanent incapacity that should be allocated to this, and this you use the employee. The director will come up with the compensation payable depending also on your salary. Okay. Yeah. So it is a mathematical formula.
All right.
Yes. It's not something that is at large.
Okay.
Yes.
I think we've learned a lot in this broadcast. I personally learned a lot. So for people who have queries, how can they reach you?
They can always reach me firstly through you, through this
secretary,
through this engagement. But I would prefer an email through titusmugambimutua@gmail.com.
All right. So we've come to the end of our broadcast. I would like to give our thanks to Chigiti and Chigiti Advocates for facilitating the shooting of this series. For our video crew, Mushiri Frames, they will share their email address on this video. And to you, our viewers, for sticking with us, your questions are welcome. Please write to us at info@cyroglobal.com. That's info@cyroglobal.com. And we still use our old email, that is cyroglobal@gmail.com. Take care of yourselves. Goodbye.